actually was employed by the Australian Law Reform Commission in the 1980s when they had a reference on evidence law. And it was the product of that long reference which resulted in the enactment of the Evidence Act 1995 New South Wales and the Evidence Act Commonwealth 1995. Because I'd been heavily involved in the Law Reform Commission work, which had resulted in that legislation, it seemed sensible that by that stage I'd gone to the bar and I was practising full-time, that it would be sensible to produce a work which discussed the new legislation. So the first book emerged in 1996. Ever since, I've been practising continuously as a barrister, but obviously maintained a strong interest in evidence law-related issues. And every few years, it's been necessary to produce new editions to take into account important new decisions, some of which I'd appeared in as an advocate. Well, those jurisdictions obviously had the benefit, the ACT and the Northern Territory obviously had the benefit of all the case law that had come from other jurisdictions in respect of virtually identical statutory provisions. So, not surprisingly, those courts were generally following decisions from other jurisdictions on the same provisions. That said, new issues have arisen in those jurisdictions and they've had to confront uncertain issues that are not resolved, and indeed they've had to deal with disagreements between intermediate appellate courts from other jurisdictions. That in turn has generated more, on occasion, more uncertainty and has needed, in some cases, the High Court to look at issues. The Northern Territory Court of Criminal Appeal had handed down a decision in respect of a number of provisions of the Evidence Act, Section 97 in particular and Section 137. Both of those provisions are essentially uniform around all those jurisdictions in Australia which have adopted the Uniform Evidence Law. It was an opportunity for the High Court to resolve a dispute that had arisen particularly between the New South Wales and Victorian Courts of Criminal Appeal about the meaning of the term probative value in the Evidence Act. That's a very important term because it appears in a number of provisions of the Act which have significant practical implications. It's defined, but the actual content of that definition, the way it's to be applied, had generated a considerable amount of controversy and uncertainty. So we took the case from the Northern Territory to the High Court. The High Court handed down its judgment, as you know, and it has, to some extent, resolved the dispute in respect of probative value. In particular, the High Court held by a 4-3 split that when a judge is assessing probative value for the purposes of determining admissibility, particularly in relation to 97 and 137, that the judge is required to assume that the evidence will be accepted as both credible and reliable. That has certainly resolved one controversy, but the implications of that analysis and its precise application in particular situations remains a matter where I think there's going to be further litigation and potential uncertainty, and equally the judgment of the majority in respect of the test in 97 and 98 of significant probative value, that in itself is, while it's provided some guidance, will, I think, raise as many questions as it provides answers. At the High Court level, apart from IMM, which is a very important decision, there's been the decision of the High Court in Honeysett, which was argued by a colleague of mine in my chambers, on expert evidence, which again is important because it says things about the application of Section 79 of the Act to expert evidence But again, I'd have to say, in one sense, raises more questions than it answers, and I think that will have to play out over the course of time to see where it goes. I was involved in another High Court decision called GW, which was an appeal from the ACT, which was an important case on unsworn evidence, particularly in respect of children, and the rules relating to the competence of children to give unsworn evidence, and also what directions, if any, are appropriate to be given by a judge to a jury in respect of that evidence. In 2015, Victoria made some significant changes to the Victorian Evidence Act by when it introduced the Jury Directions Act 2015, which had the effect that provisions relating to jury directions which are contained in the Evidence Act are now found in that other piece of legislation. And they've also made changes to how the law operates and in terms of obligations on judges to give directions to juries about certain kinds of evidence in criminal cases. I've taken the view that even though it's been taken out of the Evidence Act, that it's appropriate that there be some commentary on that new legislation, and I've done a reasonably comprehensive analysis of it to assist Victorian practitioners. One area of divergence between New South Wales and Victoria was dealt with by the High Court in IMM, and that was the approach to the meaning of probative value. In future, I think the focus in that area will be on the implications of the High Court decision. One view of the High Court decision is that there is still a considerable scope for judges to exclude evidence, particularly tendency evidence and evidence which raises risks of unfair prejudice, taking into account matters that go to the reliability of that evidence. But that will have to play out in the courts in due course. There are other areas of disagreement between the New South Wales courts and Victorian courts, for example, in relation to tendency and coincidence evidence and the proper approach to that, which is separate from the issue of assessing probative value. That will have to play out, unless, of course, the High Court decides to grant special leave on the issue and attempt to resolve it in a future decision. All one can say with any confidence is that it's unlikely that we'll have absolute certainty as to the meaning and application of these important provisions anytime soon. Look, it's very difficult to engage in crystal ball gazing, and there's an element of chance in what issues get grants of special leave to the High Court. But I think the Honeysett case clearly indicates that there's likely to be controversy about the application of Section 79 to expert evidence and to what extent that provision is interpreted in a way which has the effect of excluding what one might call junk science. That's a big issue, and I think the courts have yet to really grapple with it effectively, and I anticipate there'll be important decisions in that area. I think there'll be decisions too in respect of directions to juries and how that should play out, because the Victorian legislative amendment was designed to restrict obligations on judges to give warnings to juries about evidence, particularly if they're not asked to. But I think there'll be some pushback from judges saying that there are cases where it's necessary for warnings to be given, even if they're not asked for, because of a risk of a miscarriage of justice. I think there's going to be continuing issues about the problem relating to privilege, that we have statutory provisions which apply in certain circumstances and the common law applies in others, and I think that attempts have been made to resolve that problem in the past, but it still sits there and creates difficulties. One of the new areas that I've written about in the latest edition is one where there's a question as to the operation of Part 2.1 of the Act relating to witnesses, whether that applies to affidavit evidence. I've discussed that in some detail, and I suspect that that issue will have to be resolved at a fairly high level in the next few years. Putting in all the legislative provisions in full, of course, adds to the length of the book, which is regrettable. But on the other hand, it minimises the risk of confusion. When a practitioner goes to a provision, the last thing you want is confusion as to what precisely the terms of that provision are. Now, there's a high level of uniformity, as we know, between different jurisdictions around Australia, but there are differences, and it would be awful if confusion as to the precise words of a provision resulted from failing to put the entirety of the provision in the book. So we've made that decision. I think it was the right one, and I think practitioners will be grateful for it.